Hi there. So I was just explaining it. I'm Steve Durbin. I'm data protection officer for a large number of organisations, and I run a company called XC Distributions Limited, who do data protection, cybersecurity, interim management, stuff like that. Okay, so my expertise in this is basically actually running and managing the stuff. And a deep, long experience of data protection law going back to the 80s. Yes, I implemented the 84 Act for somebody. Okay, so what we're going to look at today is these two the bill and the amendment to the Investigative Powers Act. So we're going to look at history of the two bills, where they came from, how it all works, how it hangs together. On the data bill, I am focusing on the part 2 of Data Protection Act 2018 bit. That is the public processing, general processing. I'm not going to look much at the law enforcement and investigate intelligence processing, because there aren't many people in those communities here, but also because they're almost identical. There's hardly any differences between them. So that's going to be our outline. In terms of the history of the bill, this goes back to the previous Conservative government. So it was first introduced by the Johnson government in 2022, and then it got dropped by Truss 2 days after she came in. Okay, and then a replacement bill was put in as a number 2 bill under the Sunak government. That basically got through to committee stage and then got dropped and reintroduced without the number 2 again, and then rushed through all its common stages in literally 1 day. Okay, so that was a bit okay, fine. But then it was stuck in the Lords at the time they called the snap election, and it got dropped. Then it wasn't put through in the wash-up. This was then reintroduced as the Data Use and Access Bill, completely different title by the new Labour government. Okay, and it started in the Lords. It's now in its final common stages. And I put the picture of the Who up there, and the song Won't Get Fooled Again, because the song Won't Get Fooled Again ends with the words, "Here comes the new boss, same as the old boss." And that's basically what we have here. It's practically the same bill. It's all been reordered, but the wording is almost identical in the bits they have kept. And we're going through other detail of that. Obviously, that's what we're here for. But it is fascinating how similar it is. Makes you wonder about how big the divide in UK politics actually is these days. So, what do they want to do with this bill? Well, this was the government's wonderful publication on the day they published it. Okay, improve public services, boost the UK economy by £10 billion. Yeah, that's rather a lot, isn't it? That's an interesting assumption, but that's what the plan was. Okay, to free up the power of the economy and stuff like that. They reckon it's going to save 1.5 million hours of police time and 140,000 NHS staff hours per year. I'm not quite sure how it's going to do that, because it doesn't change things like the subject access rights stuff, which is what we spend most of our time on. So it's a bit odd, that. Okay. And then it talks about in that a map of the UK's underground infrastructure. I'll talk about that, and those are the 3 big aspirations. Well, the question we have to ask ourselves is, will it really? Well, the first thing to look at here is this puts our EU adequacy decision at risk, and I'll be talking about that in a bit more detail later. If we lose that, the estimated cost of that alone is 744 million. They say the net benefit is 10 billion over 5 years, but when you look at the error bars, they are huge, okay, to the point where you could be looking at even not taking EU adequacy into account, as low as 900 million saved. The NHS savings assume there's great reductions in efforts of data sharing and software costs and things like that. The bill doesn't really do enough to do that. So I'm very dubious about those, and a lot of my work is in the NHS. In fact, a couple of several NHS colleagues here, But also, there's a assumption in the bill that data sharing identity verification services will save us all money. I'm not sure it's that high a cost, but there you go. And also, some of the things in the previous bill have been left out in drafting on this one. So one of the big cost savings they were talking about was not having to have country reps for companies outside the UK. That's been left in this time. They took it out and forgot about it, apparently. So we are where we are. So I'm dubious. Okay, but there you go. The link at the bottom there, by the way, I will share the slides, is actually the assessment by the government of how much it's going to be worth, which does include that area about country reps. So how does the bill work? Well, it's huge. It's 271 pages for starters, okay? But basically it's split into 8 parts. 4, 5, 6, and 7 are not new law. They just amend things. This is very, very common in government. Effectively, what they do is they amend acts, and then eventually, when the acts get too difficult to read because they put too many amendments in them, they merge them up. So we've had, for example, all those various NHS acts, but in between those NHS acts, there's been amendments to them practically every year. The problem with doing it this way is that you have to read all of the bills being amended in order to understand the impact. Now, sometimes they're very nice and produce what's called Keeling schedules to help us, where they actually redline the bills and mark what's being changed. They haven't done that for this one, so I had to do an awful lot of manual work on this. Okay, so there are going to be errors in this presentation because I had to do it all manually. A lot of the things are just minor, but some of them are quite significant. Much of this is also enabling stuff rather than actual statements. So what that does is that they're commonly referred to as regulation powers, or if you're more cynical like me, Henry VIII powers, because Henry VIII liked this sort of stuff. I'll talk about why later. Parts 1, 2, 3, and 8 are new law. So about a third of the bill is new law. Okay, and all the schedules are mostly just amendments. So, you know, for example, there's a whole schedule of amendments to the Data Protection Act. And usually on this, there is a statement saying it is not compliant with the Human Rights Act. I've not seen that on a bill for a very long time. The reason it's not compliant is because some Lord's amendments, which are well-intentioned, have sort of backed the government into a corner in how it works. That'll have to be fixed during the Commons reading, so they can't actually pass a bill unless it's compliant with the Human Rights Act. Give you an idea of the extent it's altering and what the previous bills looked like. I know you can't read that, you're not intended to. Okay, just give you a feel for it. Anything on there that is in normal text black, okay, was amended by the previous bill as well. Anything that's in red is new and has only been amended by this bill. Okay, and anything that's in italic and blue, okay, is stuff that was only amended by the previous bill and isn't amended by this bill. But you can see there's an awful lot of effects on legislation. 33 acts and regulations changed. So let's dive into the bill. Any questions on that before we move on? We all good with that? Yeah, thank you. So first of all, the bill changes a lot of definitions of things, okay? The biggest change it makes, which was in the old bill as well, is to the definitions of research, archiving and statistics, the RAS purposes, as they're commonly referred to. So section 47 of the bill changes the Data Protection Act to redefine what research means, okay? And it actually redefines it as anything that can be described as reasonably scientific. Now, I'd point to the International Whaling Convention, where they said in their scientific research whales were still allowed, okay? And that's still used by Japan today to kill whales for food because they're researching how many whales are in the area. That sort of get out of, so that's a very, very concerning change. Because of the changes, okay, they've now included in historical research genealogy, which will please my Mrs. Noen because she spends a lot of time doing genealogy. But that's an interesting one because that then means that it frees up an awful lot of personal data for still living people that could then be used for genealogy. Positive changes in some ways, I suppose. Public health processing is now restricted to where it's in the public interest. So you have to do a public interest test for anything to do with public health. Okay, that works because public health is supposed to be public interest. You may find some interesting challenges with that, but that should work. They redefined statistical purposes to be very, very simply that you must be doing things in the aggregate and it can't affect any data subject individually. So that's quite a useful change because that means for a lot of things that we do, for example, in public health, are made much simpler. So that's a positive. Section 71 is interesting because it then changes the purpose limitation principle. And what it does is it allows purpose limitation to ignore effectively the research, archive and statistics purposes. So they're treated as being equivalent purposes, and you can just do things with the data without any further permissions. We'll come back to that as well, because they also change the consent on it. The second lot of definitions are a bit more fun. These are basically changing drafting errors, stupid errors that are made in previous laws. So, for example, the Privacy and Electronic Communications regulations, which are very concerned with direct marketing, never defined direct marketing. So it's now defined. Okay. The Data Protection Act 2018 didn't have a consent for law enforcement process. Everyone used it, but it wasn't actually in there. So they fixed that. They've clarified what vexatious and excessive mean. That's useful because that was always a bit difficult. It was always a judgment call. They've now allowed legal privilege for law enforcement processing. That was another silly omission. They've changed the Sexual Offences Act to include images of adults as well as children. So publishing an image of an adult without consent or a fake of an adult without consent is now also an offence. Previously, it was only for children who were sort of involved in civil law. So that's a positive change, obviously, with all the revenge porn and stuff like that that has become a big cultural issue. Safeguarding purposes have now been made generally compatible. Whoopee. Okay, this has been a major challenge for social care and healthcare for many, many years, where basically we're always a bit worried about sharing things for safeguarding purposes because there was only one exemption for it and it wasn't quite clear. This has really improved that because it's seen now as being generally compatible, along with crime and public security. That's a big, useful change, very positive. Okay. The third lot of definition changes are a bit more challenging. So first of all, the consent requirements are changed so that some things are okay to do even if you can't get consent if you're personal consent basis. That includes research. So if you give a consent to, say, cancer research, okay, that consent can then be used for any other research purpose without a further consent. They don't have to contact you if it's too hard or if they don't want to or whatever. This is a very major change. So effectively, any research consent you give is a general consent for that data to be used in any research, be it public or private, as long as it is broadly scientific. That's a very big change in consent. Legitimate interests have been redefined. This was again in the previous bill. Effectively, you can use these legitimate interests defined by the Secretary of State under a Henry VIII power. Yeah, it will curtail a lot of people consent in dev. I completely agree. It's a likely issue. Okay. It will effectively you've got a list of legitimate interests that are already pre-signed off. Yes, you can just use these. Some of them quite useful. Security, that's a big one for people that work in cybersecurity like me. That's always been a challenge because we always had to put that purpose in. Internal admin and intergroup transfers, yeah, that's useful as well. But then they added direct marketing in. Oh, we could do without direct marketing being a legitimate interest. That really is going to cause problems because an awful lot of people out there still misinterpret the PECR and therefore will think they don't need cookie banners anymore. Not so good. It doesn't change the cookie rules, by the way, as I say. The reason for that is because all these people, there's a legitimate interest opt-outs and stuff like that are just plain wrong. They just haven't read the PECR correctly. They're assuming that the consent basis is the same as is in GDPR. It's not. It's actually a PECR consent. So that's all the definition changes. There are also some structural changes. Okay. Now, by that, I mean things that are a bit more changing the way in which data protection law works rather than just change definitions in it. So relevant international law is now a compatible purpose. They've added whole sections to GDPR and DPA 2018 to allow that use. And it gives broad regulation power. In other words, Secretary of State can literally just sign a piece of paper saying, yeah, I want to change this, to change uses and even the sensitivity level of data. So what you can say is you can say that, for example, biometrics processing for identifying an individual is no longer sensitive data. It just moves out of the sensitive data category. That's a huge change. And that one, I think, is one that the EU will be very concerned about, because effectively it means UK law can deviate at the stroke of a pen. That's a worrying one. In the previous bill, I left it in crossed out here, political opinion processing was allowed for democratic engagement. They haven't put that back in, I'm glad to say, because that was always controversial, so that's gone. There's stronger emphasis on children's data processing having stronger requirements, and there's more emphasis on codes of conduct. So there's a requirement to produce codes of conduct for law enforcement for privacy and electronic communication regulations, and also that if you are suspended from a code because you're a trade member of a code and you break the rules, the commissioner has to be informed. That's new, and that's going to be quite interesting to see how that pans out. Other things they've left out from the previous bill, which is lovely, is they've not changed the record keeping requirements. In the previous bill, they've reduced Articles 30 and 35 down a lot, so that you didn't have to keep anywhere near as many records or as many data protection impact assessments. They dropped that, mainly because that would have almost certainly resulted in losing their adequacy. So I think they just thought that was too high risk. They also haven't replaced DPOs with senior responsible individuals, which again was something the EU had a big issue with. They have increased the reporting here, which, given this bill is supposed to be saving money by reducing burden, seems a bit odd, but there you go, they have. You now have to report breach and complaint numbers to the Information Commissioner. That's likely to be on an annual basis, but it's a regulation there again, so it's up to the Commissioner how they want to do that, and then the Secretary of State signs it off. One really positive one, this has been quite a taxing one for most people working in sectors where people are involved in, say, safeguarding. Previously, okay, if you had a court case, you had to disclose all the information you had to the court. The court then had to disclose that to the defence solicitors and the prosecution solicitors equally. So you couldn't keep things that may have been harmful to people out of the way of the people that shouldn't be seeing it. Now the rule has been changed. They disclose directly to the court, and the court is under no obligation to provide information to both sides. They can decide what to provide. That's a really positive and really useful change, particularly in child safety and other areas of safeguarding, out of the safeguarding. The third lot of structure changes is that international transfer decisions now don't depend on adequacy decisions. They depend upon the Secretary of State saying, yeah, I'm happy with that country. There's a thing added called the data protection test, which is basically, does that country's regulations look sort of similar to ours? Yeah, that's okay, it's adequate. That's a huge change and quite a worrying one. And also, guess who writes the standard contractual clauses between countries? Yeah, it's a Secretary of State again. So the whole of international transfer has now been placed in the hands of the Secretary of State. That's quite a shocking change. They've also completely remissed automated processing, and the reason for this is basically AI, so that AI processing can be less governed effectively. So it can now be done on legitimate interest, but it only needs a consent if and only if it's mostly based on special category data. So AI processing within healthcare will probably still have to do proper DPIAs and stuff like that and have a strong reason for doing it. AI processing in commercial, probably less so. I was on a call this morning about a company using AI to identify the gender, age, and emotions of people entering their stores. That would basically be a legitimate interest now. So it makes life simpler, I suppose. You can also do automated processing now for substantial public interest, and again, this is a Henry VIII power. The Secretary of State can decide what a substantial public interest is. So it's much weakened the protections compared to the original Article 22 and 50, which have both been deleted. Okay. One change that we were expecting is change of the oversight bodies, the ICO being abolished and replaced with an information commission. So that's less directly controlled by the Secretary of State than the previous law. The previous law, the Secretary of State basically set all its goals. The Commissioner was completely the growth Secretary of State. This is a bit more independent. They've got regulation powers. They've got to take into account needs of various bodies. Yet the Secretary of State can require the ICO to create codes of practice for sectors and then they can be used immediately, and they become part of law, as noted earlier with code of practice changes. Weirdly, they can now enforce things against Ofsted. I've no idea why Ofsted was originally exempt. I didn't realise they were, but apparently they were. Now they can enforce against them. I wonder who pulled someone's chain there, because that's a really weird change. The ICO must also publish an annual report, okay, which details what they've done and all the rest of it. They did this anyway, but they've just made it a legislative requirement, so it's not a big thing. They've removed a lot of the stuff about surveillance changes and DNA changes in the bill. So those were quite controversial, so it's nice to see them gone. Okay. In terms of changes to people's rights, this is quite a big area. So a research consent is now absolutely general, as I mentioned before. They've clarified time limits. That was always a big bone of contention. Okay, if you had somebody who sent in a subject access request, you couldn't identify them. The clock carried on ticking until they did identify themselves. You could end up being late because of someone else's actions. They fixed that. Okay, so it's a bit more like the way freedom of information works now, which is positive. They've restricted the subject access right to a reasonable and proportional search. So that's a challenging one. So it's exempt, okay, particularly for the research archive statistics purposes, if it's disproportionate. So in other words, if you've got someone's data in a database and it's pseudonymized and it will take you a lot of effort to re-identify them, you probably don't have to. If you've got 20 years worth of paper records, you probably don't have to search those either. That's a big weakening of the subject right. And that's a concerning one to my mind. The one that really made me bang my head against the table is cookie storage is now allowed without consent. However, it's limited to statistics, website improvement, website presentation, security fraud, technical faults, and breadcrumb trails. Okay. You can object to the data use, but they're reliant on browser tech doing it, and the browser tech just isn't there. So effectively, it's a free-for-all on cookies. Notice that doesn't include marketing. Marketing is not in that list, but I expect that to be parlayed by organisations into, yeah, we can do this because your browser doesn't object, because your browser hasn't got the capability of objecting. So that's not very good. There's a lot of further restrictions for national security, so that's fine. They're fairly positive ones, but they're mostly restrictions of rights. There are reasons for them, but it could actually result in us actually getting in front of the Human Rights Court again. And I would point out we have been several times already about this, despite the fact we founded the thing in the first place. But there you go. There's further rights reductions in terms of there's a removal for Article 1314 requirements for the research, archive and statistics if it would impact their purpose. So what does that mean? What that means is I don't have to tell people that I'm using their data if I think they don't want me to. That's one interpretation. I'm not saying that's the right one, but it's a possible interpretation. They've added a whole chapter 8A to the data protection, to the UK GDPR, and that basically enables processing to pseudonymized data for any of the research, archive, and statistics purposes. That one's the one that's going to save the NHS a lot of money. Currently, we have to get a section 251 for all processing that takes you from identifiable data to pseudonymized data, and we have to apply opt-outs and all sorts of other things. That gets rid of an awful lot of that. That's a surprising change. Depends on how you feel about the privacy of it, whether it's positive or negative. Okay, I think a lot of the research community are going to go whoop whoop. I think a lot of the general public are going to be going, really? Okay. So this is also pushes towards allowing the secure data environments, and of course we had the Sudlow report thing, which basically is how we're going to end up with centralized huge amounts of data. There's more on that later on. You're allowed to now do direct marketing for charity via email for charitable objectives, okay, but not for political and other non-commercial objectives. They've taken that bit out. Ooh, that's a relief. Okay, but it does mean you're going to get more charity spam. You can object, but the organisation can share data with people with similar objectives. Similar objectives is not defined anywhere, so basically expect that if you're on a mailing list for one charity, you'll be on a mailing list for all charities. That's probably the way it's going to work. Okay, so that's all the major changes. I'm going to move on now to talk about some other bits. Okay, has anyone got a question? I see one question in there. Eric asked, Steve, which SCC is responsible for them? So basically, SCC standard contractual clauses are the things that you use as a transfer mechanism between a country with an adequacy decision and one that isn't. So if the UK is, say, transferring data to Australia, which doesn't have an adequacy decision at the moment, okay, we have these limitations to ensure the same level of rights are applied. The big change is the Secretary of State is now going to be writing those, not the Information Commissioner, so they can be more politically influenced. That's the big change, and that's going to be interesting because I think what it will allow them to do is write SCCs that are deemed as being compatible with countries that don't actually have compatible data protection laws. It makes it a political decision, as with adequacy. Okay. Nothing else? No hands. Okay, I should move on. Right, I've banged on about Henry VIII powers quite a bit, and I haven't really explained what they are. Okay, so there's 60 of them in this bill. Okay, there was only 53 in the previous bill. I did have that miscounted, by the way. If anybody saw the previous presentation, I had too many. I do apologise. Effectively, this allows what's called regulation powers. You can modify the law without much parliamentary scrutiny. It's commonly called Henry VIII because Henry VIII liked this because it meant he could rule by decree effectively. Most of them require what's called a simple vote of the House. The House just has to divide on it and take a vote. That's called affirmative resolution. There doesn't need to be a debate on it. Okay, just a vote. Some of them require that the regulation is just published. If no one objects within a certain number of days, it goes through. That's called the negative resolution process. The thing about this is, for a government with a majority, they allow law to be changed easily and a lot under the radar because people don't look at these things. No one reads Hansard every day unless you're a geek like me or you're a journalist, so it's quite important. So what sort of things can we change for them without any further consultation? Well, the whole of the bill. That's down there in section 142 of the bill. The whole of the bill can be rewritten by the Secretary of State without any further parliamentary intervention. What's a legitimate interest? What's special category data? What's a meaningful human intervention in an AI situation? What's a significant impact? And what's a safeguard for automated processing? What's a safe international transfer? What's compatible further processing? And like I say, there's 60 of them in there. And as you can see, that list has only got 6 in it. So there's another 50 odd still waiting to go in there. It's huge. Effectively, the whole thing can be rewritten on a whim. That is probably going to again cause issues with Europe because Europe is going to look at that and say, well, we can't guarantee your law's going to stay compatible. Okay, so I haven't really mentioned some of the big bits in the bill, which are the data grabs. Okay, now effectively what these are is a massive increase in the amount of data that can be held by government or by the private sector and how much as a population UK people are surveilled. So as I said, the research consent is now general, so effectively any research can be done on data you've already given. Okay, the use of pseudo data is just generally authorised. You can't object to it, so that's a big right gone. There's new law on customer and business data grabs. Okay, these are powers that to require traders to retain information about customers and business transactions. Okay, power to require the traders to use specific systems to store those things in. Power to do the same for FCA regulated bodies, banks, etc. Power to require businesses to share with them, and pay for it as well. Okay, and power to take the data and use it elsewhere. And all these are just powers. They don't say what they're going to do with it. These are just powers given to the Secretary of State to do whatever they like. And the weird thing about this is it's retrospective. So they can now say any data you're holding at the moment, we're going to grab as well. That's very rare in UK law. It requires internet service providers to keep data in connection with the death of a child. Now, they've modified that one. In the previous one, it basically required internet service providers to keep everything because it might involve the death of a child. They've moderated that so it's a bit more sensible. But also, okay, internet service providers are subject to research regulations and require data provision for things like metadata. So if people want to investigate how the internet's being used, stuff like that, that data is now freely available to them. That's a huge change. There's also a change to keep biometrics, not DNA, but other biometrics, indefinitely for law enforcement and to use data from overseas for counter-terrorism without any further permissions. This allows things like the very controversial face recognition systems now in use. For example, all London police now, their body cams now do face recognition. So you might get arrested just because you walk past a constable. So we've had this in Wales for a while, but it's now extended much further. And this allows far more retention on that data. This is the bit where I have to admit a mistake. When I was preparing the slides, obviously I was comparing them with the previous bill, and I had to cut out bits where they weren't included and mark them in red and crossed out so that people knew what had been removed. Unfortunately, I mismarked one of them in red, which was this slide, data grabs 2. Basically, the social health and social care provisions have been removed and the education provisions, so they haven't got this data grab anymore. Although, taking into account the effect of the other data grabs and the regulatory power that the Secretary of State has over health and education data, it's likely they could still do the same thing if they wanted to. So just bear that in mind. My apologies for the error in the original transcription, which I have notified to all the attendees, as well as putting on this video. Thank you. It allows the Secretary of State to define what system you use, where you store the data, and who you give it to. And you have to meet the requirements of it. So that means they can dictate a patient system for the NHS. They can dictate, as per the Sudlow report, a national critical infrastructure containing all NHS data. Yep, all in there. That's a massive change, but again, not one that wasn't expected. Okay, I put on I left on the bottom there the cynical comment: NHS Digital will never sell your data. That was a promise on the NHS Digital website. They abolished NHS Digital and made them part of NHS England. They now abolish NHS England as well. So it's moving back into political control. So that's going to be happening. Got a question there from Eric. These data grabs, will they be legally obliged to provide to a is that a rogue government or a host government? What it says at the moment is that you can be required to provide data to anyone the Secretary of State requires you to do so. So effectively, the answer is yes. Okay, because what they could do is they can just say, right, this is a data provision notice in the same way we had a control patient information stuff. Okay, you now must provide data to these people for this purpose. So yes, they can pick people with company names that come from place in Lord of the Rings, like Palantir, okay, and say you must provide all your data to Palantir, and it's a power. Okay, so effectively it becomes a legal requirement. Like I say, it's not a small bill, this one. There's a lot of miscellaneous stuff in here, and I'm going to cover that now. So they're finally making births, marriages, and deaths electronic. Whoop-de-doo. That should have been done 20 years ago at least. But anyway, that is now going electronic. And we're now going to have an underground asset register. Those of you that haven't worked, as I have in things like highways, probably don't realise we don't actually know what's underneath the roads. We have to dig them up to find out a lot of the time. And sometimes we cut through things that we didn't know were there. So this is a real positive. Okay, that's something that should have been there years and years ago, but no one's ever bitten the bullet on it. So now they're biting the bullet on it. Ooh, bloody Ray. More worrying in some ways, because it's unclear what it's going to be doing, is a UK data dictionary. Now that effectively seems to be the Secretary of State having a power to dictate how data is stored and how it's used. That's a bit concerning, but that's what it is. Okay, so it's there. Okay. There's also digital verification services. This is new law, but again, it's not unexpected. They've been trying to get this through for years. Okay, this is effectively allowing people to verify your identity online. It's mostly targeted immigration enforcement at the moment, but it will effectively be an identity system for everyone online, for anyone in the UK and outside the UK as well, because they're allowing it to grab from other governments too. Okay, and all of it's changeable by regulation. So what they do with it is entirely up to us. Okay, so I haven't mentioned much about AI yet. There had to be something about AI in here, didn't there? Of course there is. So there is a separate AI bill, okay, which actually contains the first UK definition of what AI is, which is quite nice. Okay, that bill includes having AI officers. That's a bit worrying. Okay, we haven't got enough people already to do things. That's going to be a challenge. I don't know how that's going to work, but you're required, if you're using AI, to have an AI officer. Oh, right, okay. It's a private member's bill, it may not go through. There's regulation powers requiring the supply of the record of training data sources where you got the data from, and requiring more transparency. But that's a separate bill from this. I'll just include it there because it's important. The changes in this bill are to do with web crawlers and the enforcement of copyright. Now, this strikes me as being a horse, but the stable door was open, the horse has bolted, and now you're trying to close the stable door. They've already trained all their AIs on stuff up to about 2018, and now you're saying, oh, we're going to enforce copyright on it? Yeah, that's not going to work, is it? So anyway, there's got to be a regulation put before Parliament in 6 months. We've got no idea what that's going to look like. Okay, you've got to have transparency on the crawlers and how to complain, and crawlers got to be transparent about where they got their data from. I run many websites for a lot of people, and on those, I've had massive problems with the levels of traffic from those, sucking up images and comments and text and stuff like that from these. So, for example, we run a website for a people that do game run through. So they record themselves running through games and stuff like that. All that data they tried to suck up. It was crippling my service for 2 months. That's the sort of level of things they've already trained on, and now we're putting in regulation. Well, whoop-de-doo, but we could have done with that 5 years ago. Okay, so I'm going to summarise the data protection changes before we move on to the changes in investigatory powers, which are actually quite powerful. This is a massive change in data protection law. In a lot of ways, it's actually as big as what happened in 2018 with the GDPR. Okay, lots of rights amended or weakened. There's a removal of lots of independent scrutiny methods. Okay, commissioners are being removed, others are being put directly into political control. I've some changed that now, it should be 60. Primary legislation can be changed by all this stuff because they put so many regulation powers in there. There's some bits of protection in there to stop people being able to sue the government because they can do it by regulation. Okay, and it can all be changed or extended easily. So that's the data protection bit. Any questions on that before we move on to the investigatory powers bit, which will take us about another 10 minutes? Nope. Okay. Okay, so the investigatory powers changes go back a long way as well. Okay, so we had the 2000 Act and the Telecommunications Act at the same time, and the European Court of Human Rights declared those in breach in 2006. They didn't actually come into force until 2004, so it was that was fine. So there were then amendments in 2014 to comply with that, and then they wrote a new Investigatory Powers Act in 2016, which was a complete rewrite. These things are always basically about what we tend to refer to in the cybersecurity trade as the four horsemen. Okay, so that's child sexual abuse, drug dealers, money launderers, financial fraud, and terrorists. Okay, those are the four horsemen things. Everyone always says, oh, no, we need this massive oversight regulation because of those things, despite the fact those things are incredibly small amounts of activity. It's effectively surveilling the entire country in the same way that you did in George Orwell's 1984, in case anyone steps out of line. Okay, it is in many ways thought of as overreach. It depends on your view of it. If you view those harms as being so important that we should all be surveilled, that's up to you. Okay, personally, I think there's a balance to be had there, but anyway, after that, the Investigatory Powers Act was published. The again was declared in breach of the European Convention on Human Rights. There's a surprise. Okay, so we had to amend the regulations in 2024 to allow things like journalistic freedom and stuff like that. So anyway, that was changed. So. This is currently, along with the data use and access bill, a concern for the regulators, and that link I've put at the bottom there is actually the link to the EU think tank paper on it, which is basically saying, ooh, it doesn't look like the UK is going to be able to recertify its adequacy in July. I'm expecting that possibly to be extended, to be honest, because they haven't actually thought about it yet. I can't see they're going to have time to do it. So what is in the Investigatory Powers Act 2016 as amended by the new Bill 2024? There's over 200 provisions in that one. Okay, it allows interception for some legal purposes, but generally it's an offence. So there's a general authorization for business recording by a regulation, but you have to inform the person that you're recording that you are recording them if it's on the communication system. This is completely separate from the requirements for consent and transparency in GDPR. This is an additional requirement on telephone recording. And as usual, there's massive regulation powers, 22 of them in this one. So again, basic structure of this bill is effectively part one is just definitions really and defines the offences. Part two says, yeah, you can do it under these circumstances, like where there's a requirement to detect crime, where there's national security at risk. Part three is about how you do that overriding. Part four is about how you notify when you're going to be keeping data for later review. Part five is about tampering with equipment, so you can install bugs in people's phones, stuff like that. Part six, bulk warrants, is an interesting one. We'll talk about that a bit more later. Okay, effectively, this is for large amounts of personal data at scale. And part 7 and 7B allow for bulk personal data set warrants. I'll talk about that one a lot more too. Part 8 is the oversight arrangements, which are basically all there, but they're all secret. We'll talk about that. And part 9 is just all the, well, we need to change that law over there because we changed that over here, all consequential amendments. So what's the big issue with the Act for Data Protection and Human Rights? So all of the oversight and review bodies sit in secret. You have no right to know what's going on in those bodies, not even to know if there's a case in them. Okay, there's absolutely no oversight. Most people never know they're being intercepted. There's very little legal redress. This is part of the reason why the EU is very concerned about it. Okay, there are wide immunities for people, so even if the law is broken and you found out about it, it's often not possible to take action. So, for example, there's a general exemption for civil servants, so that if they took surveillance action that turned out to be illegal, they can't be sued for it. What? Anyway, it's there. Interception of metadata is regarded as being much less intrusive, so they can do that anytime. That's a real concern. Metadata is really, really detailed these days. Sorry, for those who are not aware, metadata is where, say, for example, I send you an email. Okay, the content of my email is not metadata. The headings of it, who I sent it to, how it got transmitted through the internet and stuff like that. That's all the metadata. The stuff that isn't the content, the stuff about the house, telephone numbers are metadata. Yeah. Okay, so generally this means that generalized mass surveillance is now normal and accepted. There's a requirement to notify if you change encryption in a product. So effectively, if you decide to include end-to-end encryption in your product, you have to tell the Secretary of State, and the Secretary of State can tell you, no, you're not doing that, okay, before you're allowed to change it. We've then got these lovely things called BPDs and TCNs. So I'll talk about them in a second. I'll explain the abbreviation. So let's start with TCNs. TCNs are technical capability notices. Technical capability notices basically require a telecom provider, that is anyone that transmits data over anything and does it for other people, okay, to change systems so that data can be intercepted, so they can pass data security services, and effectively that they can require data not to be end-to-end encrypted. This is why the Apple case, which got leaked because it's all supposed to be secret, is so important. I have no doubt they've issued TCNs to every organisation providing data services in the UK. The government, when they originally put this provision in, said, oh no, we won't use this until there's a wonderful way of intercepting it without reducing security. Yeah, they lied. Okay, actually, it's not complicated. It's more complicated than that because it was the previous government, and the previous government not allowed to bind current government, so technically it's not a lie. But yeah, we always knew this was going to happen. Okay, but what that means is you can't have end-to-end encryption in the UK anymore because they'll just issue a TCN saying that they require it. We don't know any been issued. We know an Apple one has got leaked. Okay, but like I say, most likely everyone's been had them. So don't expect security on any of your communications in the UK unless you roll your own, and then you become a telecommunications provider, and then you subject the law. So. Bulk personal data sets are an even more interesting thing. Basically, this is personal data where they don't think that the whole of the set is of interest. They think that maybe there might be a few people on there, but they don't have to even think that. But they can still hold the entire data set, okay, as long as it doesn't contain protected or sensitive data, and there are definitions for that. Okay, and basically they can review it and look at all this data without a warrant, and they're only allowed to keep it if they get a warrant and they get agreement. Warrants can be issued for any of those 4 things. Notice the last one, if the Secretary of State thinks it's okay. There's no restriction on the Secretary of State's powers here at all. So I think it's very likely that everything like, say, your directories for your for email from people like the major providers, Outlook, Yahoo, and so on and so forth, are all going to be sucked up into this because they can. Where they require judicial review, I love this one. Where they require judicial review, they can proceed without it in urgent cases. Then it's got to be reviewed, but it's not an offence if they say no. So effectively, there is no regulation on this. There's no apparent restrictions on cross-matching, re-identification, stuff like that. There doesn't appear to be any restriction on the powers here. So that's a fairly big privacy invasion. So basically, the whole thing is rebalancing privacy versus security on the security side much, much more than previously. Add in those Data Protection Act data grabs, and we've got even more of a surveillance state than I think most of us thought we were going to have. It's a massive structural weakening of UK security via technical capability notices. So if you are writing a software product in the UK, it's very, very likely that you won't be able to build it with sufficient encryption because you won't be allowed to. That's going to affect the UK software market quite a lot, I think. But there you go. That's where we are. Okay, I would point out that the only other regimes I am aware of that do this sort of thing are ones like China, okay, where they require that sort of level of monitoring. So there you go. Okay, we're on the same par now. And the fact these databases are going to be routinely available for matching is just quite shocking. Okay. So I didn't bother with the general summary in the end. So there you are. Over to you for questions. I hope that was interesting and useful and probably a bit shocking, to be honest. But there you go. I didn't say it was going to be an easy ride. Okay. So any questions?
Hi, Steve. Can you hear me?
Yeah, I can hear you. Go ahead. Yeah.
Which Secretary of State, as I put on the text, is
responsible? Right, it depends on which part of the Act you're talking about. I was deliberately leaving it the Secretary of State. It is a Secretary of State. For some of the intelligence ones, okay, it's any Secretary of State. Okay, so pretty much any of them can sign something off. For others, it's the Secretary of State for Health or the Secretary of State for Industry and stuff like that. It varies a lot. Bear in mind that they can change it anyway. It does actually say in the bill, if you wanted to go through them individually and see which ones it relates to. Generally on this bill, the Secretary of State is likely to be, hang on, I'll have to pull the bill up, the one that proposed it, which is, I've forgotten which department proposed it. Sorry, I should have opened the bill before I came in because I knew I'd get a question about the bill, didn't I? Come on, quicker. Okay. Right, so I will answer that question. Are there any questions in the chat while I'm doing that?
Okay.
Okay. No. Okay. Yeah. So I'm struggling to open it, but basically, if you look at the bill itself, you will find that at the top of it, it's got the Secretary of State's name that is the one most common in it, and that is Department for Science, Innovation and Technology. But a lot of them are individual Secretaries of State. So in a lot of cases, like I say, it's general across government. You can have anyone you like, whatever you fancy. So the whole thing is quite a big ability for the government to change the law on it. Okay. Right. Any other questions? Okay.
Basically, all our data is up for grab, and there is nothing we can do about it.
I think that's quite a reasonable summary. Yes, Belgium. I don't think you can.
I'm really depressed.
Any other way?
Steve, thank you.
It is pretty much that, but it's all for your own good. Of course it is. Yeah, it's to stop all those 4 horsemen.
Of course.
of course. That's what it's all
Terrorism
for. And to make sure the
and-
country can improve and all the rest of it. Yeah.
Yeah.
Okay,
And
fine.
save money.
Peter Carl, yeah, thank you very yeah. Okay, yeah, so it is quite shocking. I have to say the previous bill did slightly more than this one does. This one's been dialed back a bit, but it is still a massive change. And as I say, I'll be fascinated to see what the EU believe we should get recertified for our adequacy decision, because it is a huge rights change. In some ways, though, is it actually changing what's happening? Probably not, because the security services almost certainly been doing these things without telling people, because they didn't have any oversight before. This is probably just regulating something they're already doing. So I'm less worried about the investigatory powers one. I think they're already doing it. The weakening in rights in terms of advertising and stuff like that, I think are a concern, and certainly the ability to reuse data for anything that can be described as scientific research, that is really concerning, because effectively it means that anyone could say, oh, this is scientific research, and therefore I'm going to use all that data. Ugh, not nice.
So from the NHS side, obviously, from day-to-day thing that we do here,
yeah. So
what do we need to do? What can we do? What do we need to communicate
There's not a lot
to
we can
patients?
do. Not a lot we can do, because it's law. We have to obey the law. If it goes through, of course, it may fail. I doubt it, because it's whatever the government, and they've got a majority. The key things, I think, for the NHS are going to be, first of all, we're likely to get more patients objecting to data use, because they will see this as a further invasion of their privacy, and they're not wrong. Okay, basically an awful lot of data is going to get sucked up for the research purposes, which people may or may not feel is appropriate. The fact that if you consent to one researcher, you consent it to all, I think is actually going to cause problems for research consent, because people are going to be a lot more careful about their consent now. Now there are going to be some people, myself included, who are going to say, yeah, I'm quite happy if any kind of research be done, so long as it's done under correct governance, because it's always useful, and I've got lots and lots of interesting things wrong with me that I'm sure people are going to find really useful to research. Great, get on with it. But if you're you don't feel that way about research, you may not want it. I would point out, if you're a tobacco company, for example, okay, you could be sucking up loads and loads of data about smokers to use for research into how to sell more data to smokers. Scientific research. Why not? Yeah, that's the sort of thing that I think we need to be careful of. But we won't know until it gets implemented. Yeah.
I mean, at the end of the day, after all these things that you actually shared with us, even if you say no, then what is the value of that no? You know what I mean? They found the back door to get in there and get that data out. So that's what I'm trying to understand. I mean, the patients may come and say, yeah, I don't want my data to be shared. Where did this, how can we stop that happening? We cannot promise that.
This is why I keep banging on about opt-outs, okay? Because opt-outs are pretty much the only mechanism we have for controlling this. And this bill doesn't, I have to say, remove too many of the opt-outs. The only ones it does are on research, okay, and some marketing bits, but generally opt-outs stay the same. So I just think we're going to get
more opt-outs.
We're going to get more opt-outs, I would think, from more privacy-conscious people. Eric's asked where the recording's going to be. I will be emailing everybody that attended with the recording link anyway. But all of my stuff goes up on this channel, DPO Advice from Steve. Okay, so you can have a look at it there. Okay, and I hope that was useful to everybody.
Thank you.
No, thank you all for attending. Any further questions, or shall I close it down?
Thank you very much, Steve. Much appreciated.
Pleasure. Okay, cheers now. Bye-bye all.
Thanks, Steve.
Thank you. Bye.
Bye-bye.
Bye, Deb.